You can start, madam.
A very good morning to all. A very good morning to all. Respected speaker of the day, principal sir, faculty members, and all the participants. On behalf of Kokan Gyanpit, Rahul Dharkar College of Pharmacy and Research Institute, Karjat, I, Ms. Pratiksha Sable, Assistant Professor of Pharmaceutics Department, extend a warm welcome to our today's resource person of the day, Prakhar Singh Sir, all dignitaries on the virtual platform, and the participants for the workshop on intellectual property rights organized by IIIC, IQAC, and RADC of Konkan Gyanpit, Rahul Dharkar College of Pharmacy, in association with Government of India, Ministry of Commerce and Industry, DPIIT, Office of the Controller, General of Patents, Designs and Trademarks under National Intellectual Property Awareness Mission. When I understood and accepted my own mistakes, I was consumed by my own light. Darkness cannot drive out darkness, only light can do that. Hate cannot drive out hate, only love can do that, is said by a great king, Martin Luther. It is mark of our undying tradition to invoke the Almighty at the beginning of an important event. Like the greater philosopher once said, the function of prayers is not to influence God, but rather to change the nature of one who prays. So now I would like to request Ajay Kharche sir for virtual lamp lightning and Saraswati Pujan.
शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तु ते दीपज्योतिर्नमोऽस्तु ते शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः
With these positive vibes and blessings, we would proceed further. First, I would like to thank Ajay sir for this positive blessings and vibes. God, God gifted a wonderful thing called brain to man, and Mother Nature endowed him with the abundant physical and biological resources on the earth. Man started creating his own world by application of his brain or mind and by utilization of resources. Man has also been bestowed with imagination and creativity. With his imagination and creativity, he has been producing various articles or products for his needs, comfort, and convenience. In the earlier era, these creations and inventions by him fell in public domain. These were the common properties. Anybody could use and copy this creation and invention without any restrictions, reservation, or payment. However, with the passage of time, the importance and value of this creation was realized. By the end of 20th century, the things created and invented by the human mind were recognized as an intellectual property of the owner. Intellectual property pertains to any original creation of human intellect, such as artistic, literacy, technical, or scientific creation. Intellectual inventor or creator to protect his invention or creation for a certain period of time. Intellectual property protection is critical to foster innovation. Without protection of ideas and business, individuals would not reap the full benefits of their invention and would less focus on research and development. With this brief introduction about the intellectual property rights, now I would like to request our beloved principal sir to speak few words. Over to you, sir.
Thank you, Pratiksha. At the outset, I would like to welcome Engineer Mr. Prakhar Singh, Examiner, Patents and Design, Patent Office, Mumbai. Thank you for your consent, sir, cooperation, and for organizing this valuable webinar for we pharmacy professors as well as pharmacy students. Everyone knows the importance of patents. Nowadays, we are stressing more on creativity, innovations, startup, etc. In pharmacy, we are assigning projects to our students from time to time, from long back. We have research in our MPharm, research while doing PhD, but many of us give very less importance towards patenting the work, patenting to the product. But now it's very important. I will not take much time on this. Sir is there to inform and elaborate on what is the importance of patents. Each and everyone knows. In pharmaceutical field, many patents are there, and there is wide scope for we colleges or we professors and students while doing research for going for patents. From last 3 4 years, there is more stress, and each and every college and individual who are innovative, who are creative, and who want to move ahead for accreditation and other purpose, they are involved in this. But still, 90% of the colleges are not aware of the patents properly. So I would request sir to elaborate details of the what is IPR, what is its importance, and specifically something related to our pharma industry also. So dear delegates, you all know Kokan Gyanpith Raldarkar College of Pharmacy had organized more than 250 webinars during these last 2 years, and this year specifically, we have given more stress on the rural entrepreneurship development and patents. So this year you will, this is the first of its kind. We are starting with simple IPR, but this year every month you will enjoy and you will learn and you will be educated with at least one webinar a month on this topic, as it is the most important topic. I will not take much time. Back to Pratiksha.
I feel great privilege, and it's my honor to introduce to you the eminent speaker of the day, Prakhar Singh. Sir has completed his B.Tech Mechanical Engineering from NIT Allahabad. He has more than 5 years of experience as examiner of patents and design, Patent Office Mumbai. Sir is also the member of IP BRICS coordination team. With this short introduction, I once again welcome you, sir, and we are delighted to have you here. I feel great pleasure to announce you that more than 300 participants have joined us for the workshop. Now, without taking much time of yours, I would like to hand over the session to you, sir. Over to you, sir, please.
Good morning, everyone. This is Prakhar, examiner of Patent Design, Patent Office, Mumbai. First of all, I would like to thank honorable organizers and faculty members who have made this webinar possible, and a warm welcome to all students. I know this would have been more live for me if I could have seen your faces, but still you are there, you are seeing my face, and I hope I'll get your undivided attention, because that would be the key for success of this webinar. So here I am taking this IPR awareness session, and this is being conducted under NIPA mission of Government of India, that is National Intellectual Property Awareness Mission. It aims to aware 1 million students by the end of August 2022. So I'll the structure of this presentation would be: first I'll present some concept regarding IPR, and in the end there would be some quizzes, and later on in the last you can have your query session, and you can ask any question you feel free for that. So one more thing I want to clarify, that I may not be going into the exact data and the factuals thing. What I intend to do with this webinar is that you must be aware of the different kind of IPR we have, because we all have Google today, and once we know that what we need to do is file a patent. The procedure is quite apparently available on the site, but many of time, and we have personally faced this issue, that people come to us that we want to patent our company. That is the trademark department. Then they want to patent their book ideas, something like that. So this confusion between patent, copyright, trademark, GI, so that's what I want to clarify first, the difference between all these kind of IP. So starting with that, first of all, yes, we know all about the properties that we hold, that are tangible in the sense that we can confine it and hold it. Now the intellectual property is something which comes out of the creativity or intellect and art, which is mixed with the resources that is available and is acted upon to give some output. That output is what is called IPR. It is not just an idea in the mind. It needs to be mixed with resources and acted upon. Then comes the existence of intellectual property. So this is intellectual property, and it in itself has a wide variety of IP. So in this slide, I will just give you a brief idea, starting with patent. This is my personal analogy I made. You all have seen Three Idiot, I believe, yes. And in that, you remember the definition of machine, given not by Chatur but given by Amir Khan. Just recall it in your minds. I know you won't be able to say it here. So just recall it in your mind. The definition of machine, it was that anything that makes the work easy is machine. So patent is something which deals with that. That is, any functionality is the main point. Crux being, you identified a problem, you came up with a solution, and that can be executed. So this is the patent. The example, now patent can be like for entirely new thing, just something which is which haven't existed in the world, and it's the case of novelty where it is entirely new and you have come up with something new. But today almost in the all fields some development have been made. So what we encounter is, in the most of the cases, what we get is a further development on an existing invention. So how I'll give you example regarding that. We all have ceiling fans, right? So suppose a inventor comes with a curved ceiling fans that are spiral in nature, and now he claims that the power consumed is lesser, or say it gives a better airflow. So if he proves this, if we are satisfied that the power consumption is less because of this different nature of the fan blades, then he is eligible for patent. Means, and fan was not a new thing, but he made a further improvement in that. Functionality has been uh, uh, functionality has been achieved, that is, the power consumption was reduced, or say airflow was increased with the same power. So this is the case of patent. Moving on to the second category, design. It is all about aesthetic. So continuing with the same example will give you the best idea, that suppose the fan which our inventor made with the curved blades. So now it has been realized that it is neither reducing the power consumption nor increasing the airflow. Means any kind of benefit is not there in that fan. Still he is eligible to get IP rights. IP rights for what? Creativity. Means obviously that fan would be looking better than a normal fan. It will have value in the market, that it is much different than the common fan we see in day to day life. So he will get that in the form of design, registered design. So you getting it means if a function is being fulfilled, then we get a patent. But even if we just add a design which is unique, which have a aesthetical value, then we get designs. Trademark, okay, again example would be more suitable. You are going to a market and you want a soft drink and you ask for it. You are being given option of Coca Cola and Cola Cola. Which one will you prefer? I should not ask that, because everyone will go for Coca Cola. Why? Because we have a trust in that brand. We know it existence from years and years. We uh, we uh, we have a trust in that brand. That trust we have on a product or a service is what is preserved by trademark. Then we have geographical indication. Everyone you must be knowing about Darjeeling tea, the specialty of tea that is specifically from Darjeeling, Nagpur Santre, Tirupati Laddu, and lot more. So these are the things that achieve that get their unique identity because of their relation to a specific location. So these are the things which are given GI tags. Copyright deals with the expression of creative idea. What it protects is literary work, scientific work, and artistic work which has been expressed upon. Just idea in mind won't be copyrighted, but when it has been expressed in a materialistic form, then there comes the role of copyright. Mostly it deals with what we can say creativity and art. Semiconductor integrated circuit, I'll explain that during the slide. And plants variety in farmers right is the reason that initially patent and regime IP regime was not extended for the agricultural and products, because we as a country which wholly depends on agriculture, any kind of restriction in the same may have hampered the farmers. So, however, later on, to get in conformity with the international rules and all, we created this act, Plant Variety and Farmers Right Act, in which the rights of both the farmers and the manufacturer who are coming with new kind of variety of seeds and all, that is also important for the better productivity and better climate resilient crops. So it's a trade-off between the rights and the benefits of manufacturer. Farmers are not being hurt because for their personal use they can keep using the seeds. However, for the commercial productivity selling and all, manufacturers have a right to exclude others from selling their the seed that they develop. Now we have seen in the previous slide that there are different kind of IPs, almost like eight to now. One thing this slide shows is that they can coexist in a single product. We It's not that my product deals only with this kind of IP. So here, if you can see a laptop, can you I it's obvious the Apple sign you are seeing, and all of you know what it represents. It's a trademark. It's giving you trust that it belongs to Apple, and it is one of the best quality you can get. So the first variety we got of IPR is trademark. Second being patent, and not just one patent, multiple patent would be there in this laptop regarding touch sensitivity or the processing and all. So multiple patent within this single product. Then we have a design concept also. See the sleek edges of this laptop. So it may not be a function giving some extra function, but it is giving a great look. So the design is also involved. Then obviously SICL design that I skipped. So it is about ICs, different kind of ICs. So every ICs can get it particular design registered. So here and manuals and any kind of guidelines which comes with product comes under copyright. So in this single product we have find patent, design, trademark, copyright, SICL designs, and there can be more examples like that. So essence being that they coexist in this world, the different kind of IP. Okay, so you got your intellectual property protected. What does it signifies? That you can exclude others from using it. But this is not the only two things. Now it becomes your responsibility to utilize it commercially. This is the main essence of getting it protected, that you protect, exclude others from using it. But you cannot just sit down idle. You need to be active in commercializing it. If you are not capable personally, then you can license it out, and there are other options, so that the market, at least the public, get the benefit of that protected right. So here the some option for own use. You can license and assign. Franchise is an option. Merchandise, like a Disney, it's like protection in the multiple products. Same brand goes into multiple products, so that would be called merchandise. So these are the way you can commercialize your protected item. One one thing often realized by us, that in the academic world, many a times this patents or even papers and all kind of this IP are registered for the sense of academic points and pride, and that is okay. But again, the important purpose is commercialization, brand value, and earning. So even at the academic level, if it is being done for the academic points and a pride, but it must be linked to a particular channel, so that the students, the new startups, can commercialize also. So uh, so that they can get the real benefit of those inventions. So we should never forget the commercialization part. Patent is not granted at a global level. If you are getting a patent, you are getting it at a national level by a sovereign authority, that is India, and that would be applicable in India only. You can apply in different countries, and at every country the rights you will get would be restrained to that country. Exclusive right you get, that is you can exclude others from using your invention, and it is for limited period, and that limited period is the core essence of all this IPR. Because what we are doing is, suppose there is no kind of IPR management, then no one will get motivated to innovate anything, because they know that once they innovate, the market will be full with all the competitors, and he will not be able to realize the gains, and he have invested so much in the invention. And if such a thinking comes, then no invention will come. But suppose we give a unlimited we give this protection for unlimited time, then it will cause a monopoly. So what the IPR management does, this whole IPR system does is a trade off. The inventor is also getting the right for 20 years where he can get benefits, and then it becomes open to public, so it's a win-win situation for both. It's a exchange process where one discloses his information, gets a right to earn for 20 years, and then the product become public. When we think of patent, the first thought that appears in our mind is that it is something which is very technologically oriented thing, and only a high level research laboratories, MNC companies, and the best facilities can afford to do something, to come up with something like patent. But the first image here you can see is such a simple invention. So not much effort in the sense of technology orientation is needed, but your mind, your creativity is needed. So you identify the solution at any level, at the Ground level, you identified a problem and you came up with a solution that is eligible for patent. So patent is not something very technologically oriented. It can be as simple as a baby head being shown here. I'll also like to give one more example. It's a story. Story goes like this: that a person was being fired, and while filing all his papers, he just got frustrated because every time he used to use the pin, paper got punctured. So what he came up with the idea of this U pin, and he resigned from the company, but he patented that upin idea, and with that he made millions and millions because he just assigned the right to everyone and asked for a royalty. And upin, again, you can see such a simple invention. It just comes out in a click from your brain, and still it is so powerful and being used in almost every office of world today. So such is the power of patent, that it can be very technologically oriented also, but it can be very simple. Some more examples here. uh, just foldable, carryable hangers, and this shoe you are seeing right here. uh, can can someone identify what it is actually? Michael Jackson, you remember the step he used to do? Inclination of more than 45 degree while dancing. It was not something that was inner talent. Rather, it was a scientific talent. His shoes, and his shoes has been patented. It helped him to maintain a balance when he used to tilt more than 45 degree. Again, few more examples, simple examples of patent: light being mixed with hat and all. So thing being utility, you identify a utility and come up with a solution. Design, as I already told you, it does not serve any purpose. It is about aesthetical value, looks. I'm not going to read out the definition here. Uh, the essential thing being that there is an existing product and some artistic work is being done on that product. The thing which comes up is can be registered into a design. Like example, you see here, car is an existing product. It does not came into existence because of this particular artistic thing, the contribution you have made. Car was had an independent existence, but in that car you came up with some specific design of the bonnet or say window and all, and you gave your creativity on an existing product, and now you what you get is a registered design based on the aesthetical value. Some more examples of design in watches and bicycles, or like in bicycle, there can be cases of patent. You have gone with some new kind of brake and all, but simple some changes in the rod and all, which are not serving purpose, but it will come as a design. Trademark, power of trademark, as I already told. Here you see some logos, and yet just nothing is written there, and yet by seeing a arrow, by seeing a tick mark, that it belongs to Nike. By seeing in M, you know it belongs to McDonald's, a Hut, Pizza Hut. So this is the power of trademark, that by visual recognition or any kind of other perception also, you get the feeling of whole trust and the worthiness of that product. And this this is required for all the company when they want to establish a goodwill with their customer. So this recognition you one gets can come from out of logo, or the brand name. The name is simply the recognition we get directly. Then we have tagline also. Even if we are not seeing the Nike and the tick mark, just do it is sufficient to remind us that it belongs to Nike. Life is good, open happiness. So this is also the part of trademark. It is the part of trademark that is it includes slogan, logo. A different kind of trademark is certification mark, that they are not making that product, it does not belong to, but they have certified the product to be of particular level of quality, like bureau, like egg mark you have seen, and lot of certificate BSI certification marks. So these are the kind of trademark where they certify for the quality of the product. Sound mark, it's an interesting thing. You see in this slide a roaring lion. Can you remember, ever remember this being seen, you saw that in movie or somewhere? One thing I remember, in before Tom and Jerry, it used to roar. So this sound is sufficient to remind us that it belongs to MGM. Similarly, for Britannia, if you recall the sound they use, that is associated with Britannia. So you see here that the sound is good enough to give you to recognize, to make you feel the which company the product belongs. So these are a variety of trademark that is called sound marks. Then we have logo, and we also have a thing called smell mark. It's very rare and not there in India, and because it is not easy to represent the smell mark. And but in word there has been instances of smell marks, like in the flip flop stores, they have this coconut smell all around in the store. So they, once the person enters, that smell get their connection with the flip flop brand. So over a time, some brand develops such a recognition from a smell also, and that can be protected as smell mark. Moving mark are one of the easiest example you see in day-to-day life would be windows. Whenever you open your laptop, you see the Windows sign being circulating or shining here and there, and that is the moving mark for Windows. What should be the quality of good trademark? It should be distinctive in nature and not deceptively close to any other existing product. So these are the property one trademark should have. In our day-to-day life, in our product, if you turn back, you will find either TM or R. What does the it generally means is that for TM, trademark application has been filed. In the case of circled R, that trademark has been registered now. Copyright copyright is the expression of idea, and in a tangible form. It further have multiple varieties in itself. It can be in the form of literary work, paintings, photography, dancing. Any kind of performance of the art comes under copyright. And the rights of copyright is often called bundle of right, because it within it itself, it contains the right for reproduction, to translate, to adapt, to perform, to distribute. So just a copyright, you have written a book, all kind of rights comes with for you, like right to reproduce and translation. Anyone translating the book should ask you. And one thing with copyright, which is not generally with other kind of IPR, is that registration is not mandatory. Once you publish your work, it gets automatically copyright. But the only problem is that whenever in the case of dispute, you must be able to prove the existence of your work at some particular date. So for that, it is often suggested that if your copyright is involving some commercial competitors, then you must get it registered also. Registration option for copyright is there, but not mandatory. But it is suggested that in case of possible dispute, you get it registered. There are other ways also, you to prove the existence of your copyright. You can get it published in the newspaper. You can directly publish a book from a publisher. So These are already the proof of publication. But in case of some other thing, your photographs, where if you don't want to publish it in newspaper and all, you can simply get it registered from the copyright office. These are the varieties I was talking about for copyright: literary work, painting, photography, drawing. Sculpture also comes in copyright, music, films. Now, like in the case of patent, which was for 20 years, copyright is for 60 years, till the life of author plus 60 years. This 60 years goes with copyright everywhere, but the starting point differs for different category of copyright. For in the case of book, lifetime of author plus 60 years. In the case of anonymous work, first time it was published, or came into public knowledge, after that 60 years. All the sound recorded in 60 years from year in which recording was published. Ajay sir, I request you to play the first video regarding GI. So now what we see is a video for GI, which I already told you that where the product gets recognition from specific place it belongs.
चिंदी चोर के साथ घमासान के बाद अब आईपी नानी बिजी हो गई अपनी पोती की शादी की तैयारियों में। संगीत वाले दिन जब छोटू उनसे मिला तो
वाओ नानी, आप तो बिल्कुल छाए हुए हो। आपके सामने तो मधुबाला को भी कॉम्प्लेक्स हो जाए।
ओए, मस्का लगाना बंद कर। ये बता तुझे क्या चाहिए?
नानी, आपने तो मेरा दिल ही तोड़ दिया। क्या एक प्यारा सा लाडला सा बच्चा अपने नानी को कॉम्प्लीमेंट भी नहीं दे सकता?
अच्छा चल, एक्सेप्ट किया तेरा कॉम्प्लीमेंट। अब बता तुझे क्या चाहिए?
मुझे कुछ नहीं चाहिए, बस आपकी हाथ की वो स्पेशल वाली चाय पीनी है।
बस इतनी सी बात के लिए इतना बड़ा मस्का?
मस्का नहीं नानी, आप आज सचमुच बहुत ही रॉकिंग लग रही हो। ये साड़ी आप पर बहुत ही अच्छी लग रही है।
अरे ये तो स्पेशल लखनवी चिकनकारी है। लखनवी चिकनकारी पूरी दुनिया में मशहूर है। ये अपनी खूबसूरत और बारीक एम्ब्रॉयडरी के काम के लिए फेमस है। लेकिन पता है इसकी सबसे बड़ी खासियत क्या है?
क्या है?
ये एक रजिस्टर्ड जीआई है।
जीआई? वो क्या होता है नानी?
जीआई का मतलब होता है जियोग्राफिकल इंडिकेशंस, हिंदी में जिसे भौगोलिक उपदर्शन कहते हैं। ये किसी समुदाय का बौद्धिक अधिकार है, वो विरासत जिन्हें प्रोटेक्ट और एनकरेज करने की बहुत आवश्यकता है। मुख्यतः इन टाइप्स में रजिस्टर्ड होती है: नेचुरल गुड्स, मैन्युफैक्चर्ड गुड्स, टेक्सटाइल्स, हैंडीक्राफ्ट्स, फूड स्टफ।
अच्छा।
चल अब ना किचन में चलते हैं और गर्मा गर्म चाय बनाते हैं।
हाँ हाँ हाँ।
किचन की ओर जाते हुए नानी ने छोटू को अपना देश घुमा दिया।
छोटू,
जी नानी।
ये देख, ये पेंटिंग देख। ये एक मधुबनी पेंटिंग है, बिहार की। और ये है हिमाचल की कांगड़ा पेंटिंग। तेरे नानू को देश की कला और संस्कृति से जुड़ी हुई चीजों को इकट्ठा करने का बहुत शौक है।
अच्छा।
ये कठपुतलियाँ देख रहा है?
हाँ।
ये राजस्थान की हैं। इसी तरह छत्तीसगढ़ से बस्तर ढोकरा, आंध्र प्रदेश से तिरुपति लड्डू, असम से मूगा सिल्क, नागालैंड से नागा मिर्च और मध्य प्रदेश के बाघ प्रिंट, ये सब रजिस्टर्ड जीआईज हैं।
ओके।
ये हमारे देश की कला और संस्कृति का प्रतीक हैं। हमारे देश में हुनर और कला का इतना भंडार है कि अभी से ही 300 से ज्यादा रजिस्टर्ड जीआईज हैं।
वाह नानी।
चल अब तू चाय बनाने में मेरी मदद कर। एक बर्तन में पानी ले और उबालने के लिए रख।
यस बॉस।
पता है छोटू, तुझे मेरे हाथ की चाय इतनी पसंद क्यों है?
क्यों है नानी?
क्योंकि ये स्पेशल दार्जिलिंग की चाय है। ये देश की सबसे पहली रजिस्टर्ड जीआई है, जो 2004 में रजिस्टर्ड हुई थी।
लेकिन नानी, एक बात बताओ, इन जीआईएस से फायदा क्या होता है?
देखो छोटू, ज्यादातर जीआईस गांव के समुदाय के होते हैं। इनसे कारीगरों, बुनकरों, किसानों की आमदनी बढ़ती है। उनको अपनी मेहनत का सही दाम मिलता है और उन वस्तुओं की डिमांड भी बढ़ती है। साथ साथ खरीदने वालों को भी विश्वास हो जाता है कि वो एक जेन्युइन चीज खरीद रहे हैं।
ओह, वैसे नानी मुझे एक आइडिया आया है।
अरे वाह छोटू, तेरे को आइडिया?
यस नानी, अगले महीने फॉरेन से मेरे कुछ दोस्त आ रहे हैं। क्यों ना मैं उन्हें हमारे देश के कुछ सुंदर जीआई प्रोडक्ट्स गिफ्ट में दूं?
ये तो बहुत ही अच्छा आइडिया है छोटू। उन्हें ये चीजें जरूर पसंद आएंगी और हमारे देश की कला का नाम भी होगा।
देखा नानी, आपकी संगत में मैं कितना इंटेलिजेंट हो गया हूँ।
हाँ भाई, ये बात तो है।
और इस तरह एक बार फिर आईपी नानी ने आईपीआर का झंडा ऊंचा लहरा दिया।
So, so you saw the video and different kind of GI, and there are few more here in the pictures. But the main importance of GI has been recognized in the form of alleviation of poverty. Means the first GI you saw, dazzling tea. After that, there has been a dramatic change in the economical status of those societies, and the same has been recognized world over in different kinds of indigenous coffee taste in Africa and South America. Whole community got this GI, and the level of income they were having with that product increased drastically, and that's why the UN, we all know about the different goals from for sustainable development goals, and in it one of them being elevation of poverty. So for that, GI is being used as a tool for that, to identify different kind of indigenous product which have specific qualities and help those community to improve their life standards. And for us also, it's for a customer, it gives you a authentic quality, and you get to know that this specific product is best from that place. SICLD, as we know, we are surrounded by different kind of electronic item today, and every electronic item operate on these ICs. So rather than including it in the same as patent, here a separate category for IC has been given, where the specific way in that in which those circuit has been designed, the fabricated in different layers. We know there are different layer in ICs. So this thing, the uniqueness of those circuit, how compact they have been fabricated, how efficiently they are working, based on those criteria, this SICL design are being given. Don't get confused with the design, the second category which I explained, which was about aesthetic. It was about looks, but this design is not about look. It is about how the novelty is there, some functionality is being better in this IC rather than the previous one. The compactness is better. So on those criteria, the actual features, some functions are there which are being seen, and after that only SICL design is given. Application is everywhere, from satellite to robotics to computing and medical surgery and all. So everywhere, as of now, we are surrounded by electronics, and this is what protects IC circuits. Just a other video regarding how we are how we are surrounded by IP, different kinds of IP in our day-to-day life, and yet we remain mostly ignorant about it. So this video just attempts to show you how in your day-to-day life IP is relevant. Ajay ji, can I have a second video?
Sir, I request you to please unmute yourself. You are not audible, sir.
Sorry, sorry. Yes, yes. So I was talking about validating and patents 20 years already known, copyright 60 years for the lifetime of author, and for design it is 10 years plus 5 years. That is, it can be extended by 5 years, but maximum it would be 15 years. Trademark and GI are for indefinite time till the owner wants it to renew. So except all other kind, except GI, all other kinds are applied by individual. Individual includes the firms and the legal identity, but in the case of GI, a society, a registered society of whole community, whole area that the GI belongs, apply for GI. These are some of the points one must remember, that before suppose you came up with a invention or something new or creative, before showing it to anyone, first protect it. Before publishing anywhere, first protect it. Rights are territorial, as I told you, for each country specific. Registration is done by a sovereign authority, that would be India, government of India. Rights are for limited period. Well, yes, this no automatic relief. This is an important thing one must know, that they cannot sit on their right and sleep. They must be aware that who is infringing your suit. There is no specific department or a force which will tell you that some guy is infringing your patents right, your trademark right, or whatever. So there's no automatic relief. You must be aware of your market, your the product where it is being used, and if someone is infringing, you must file a complaint in court. So there are agents for patent, trademark, and copyright everywhere, but they are not compulsory. They are just there to support you. If you can do the process by yourself, then everything is available inside. So at times the market is with this conception that hiring some kind of agent is compulsory, but it is not. One can do all kind of filing by self. This patent application filing, I won't stress much. There are few forms which are generally used. Form 1 is there regarding your details. Form 2 is there regarding the detail of the invention which you have done. And then form 3, whether you have filed any in any foreign countries. Form 5 is regarding who is the inventor. Form 18 is the request for examination. So these are the general forms. There are other forms, and we need not to go into details, but these are the general forms you will need while filing a patent. And here's the site ipindiaonline.gov, where you will get all the specific details, what is required while filing application. Right now I don't think we need to focus on that. There is in India and many countries there have been some pendency. So to expedite the thing, a process of expedite examination has been started, which is there for startups, small entity. If any one of the this is in the form of or either startup, either small entity, or any of the applicant in a group of applicant that have applied is female, or a government department is involved as applicant. So these are the cases where the examination can be done in the expedited manner. Now I told you that when you get a patent in India, it is only applicable in India. Suppose you feel that your product, your invention is relevant in the European market also, in US also, then you need to individually approach those nations. But what happens when you apply in India, you get a priority date that your invention would be considered to have been known in public knowledge on this date, but on the same date you cannot file everywhere. So this is the route that has been provided. There are there are two ways: convention way and a PCT. In a convention, there are group of countries more than 160 which recognize the filing date of their member countries. So, like in our case, you are the inventor. You have filed in India. You also want to file in US and Euro and one of the some of countries of Europe like Germany, France. So, what you will file in India, and you will get a time of 12 months within which you can approach US also, and Germany also, France also, China also, and they will accept the date of filing of India as the date of original, as the date of priority. So this is the convention treaty where they accept the date of priority from any of the member country. And but still, if you want to while in many countries, say 12 to 15 countries, it becomes a hectic process to approach every country. So again, there is a second way, that is PCT, Patent Cooperation Treaty, which is handled by WIPO, the central agency at the global level who handles IPR. So what happens? You file a single application there. After filing in India, you file a single application there on behalf of this application, and you just mark the countries in which you are interested. So they do all the primary process, and they send the copy to all the relevant countries. In the last stage, you will have to approach those country and go on with the procedure. So as I told, the final grant procedure will be will be handled individually by each country, but the filing procedure has been made easy by PCT, that you just file a single file in WIPO and just mark all the countries, and it will go in those countries, and then you will have to take the follow up individually. This is the basic structure of how once you file application, what happens. We do a primary examination, and we note down some formal and technical points. Objection, formal objection being regarding some error in fee, or some error in signature, or any formal mistakes are noted down as a formal objection. Then there comes technical objection, the invention which have you given. In that, if some form if some the claiming is not right, the disclosure is not proper. So, and any priority, if anticipation we get that this document is same as your invention, these all come in the form of technical objection. So based on combining these formal and technical objection, we make a FER, first examination report, that is given to applicant. Within the 6 month, applicant will reply regarding those objection. Those objection and reply would be considered again. Based on that, a second examination report is created, and if some objection persists, then the hearing is provided for applicant. Sometimes when we hear this word hearing, we often get this feeling of hearing like in a court. Some applicants get frightened regarding the hearing process, but it's a very simple process where the applicant and the officer who is handling the file comes face to face, either physically or video conferencing, and they have a discussion about regarding the objection face to face. And once the objection are clear or they are sustained, depending on that, grant or refusal is done in patent. So this RG and IPM in Nagpur is our training center, and any kind of it provides a variety of course regarding IPR in all the different kinds of IPR. And you can just note down this information, RG and IPM from Nagpur, and go through the same in case you are interested for any courses, detailed courses. Now moving on, before the quiz, I'll further like to discuss on few things. Like you are from pharmaceutical background, and even in general, often public ask question whenever they hear about patents and all. They ask question that how come these foreign countries have been able to take the patents in our turmeric and neem, and the things we already knew from our ancestors, and they are using the same. So it was a problem earlier, and regarding the same, quick action was taken by government. And now we have what is called traditional knowledge digital library. It is accessible to all. You can just google it down, traditional knowledge digital library, TKDL. So what it contains is the vast record of every kind of traditional knowledge we have in the field of Ayurveda, Siddha, Unani, and even our household remedies. Ginger for bad throat, such a small remedy we know in our household. So every means a a wide variety of information is there. And now whenever a patent is granted in the field of pharmaceutical and any kind of remedies, medical remedies, it is cross reference again this database. So that and based on this only, those the patent which were granted in the for the neem and haldies and all were revoked later. And such a thing does not happen in future. That's why this library is used extensively in our office, as well as it has been shared with other offices also in foreign countries, so that they do not give the patent for the knowledge which was already there in our tradition. And one point that appears me relevant here is for there are few things which are not patentable in India, that is catered in section 3 in Patents Act. So some of them being that any invention that is against the public order, that is against the morality, will not be patented. Again, the discovery of a thing does not qualify for patent. You have to invent it, not discover it. I hope you know the difference between discovery and invention. So discoveries are incidental, and they are not they are not given patents. And in this, the most important thing for you would be the section 3D. It is about evergreening. Have you heard of the term evergreening? It's quite common in your field, pharmaceutical. So here what happens, that existing medicine is there and a slight changes in its composition. You We know the restriction of 20 years, that a company comes up with a drug and they get patent for 20 years, it is okay. Now that it is about to expire, many company tries to just make some changes in the composition, and they try to take the patent again. So this misuse has been quite prevalent all over the world. For same, we have with in our patent act this section 3D, which says that only in the case of significant improvement of the performance, this the same drug or same invention can be patented if the improvement is significant. This significant have helped us to stop the cases of misuse repatenting the existing drugs. Now, as honorable sir said, that in your college there are new ideas coming up, the startups are relevant here. So I will like to tell that recently government of India have launched a plan in 2016, startup intellectual protection. So what they try is to promote startups in the field of IP. For that, like in the case of an ordinary company, they cannot go through all the details of the processing, and also generally they take the help of patent agent. Now these agent charge heavy fees, which may not be possible for startups. That why a post of facilitator has been there. These are private agents which enroll with our government of India as a facilitator. They can be approached. Their information is there on our website, a list of facilitators. Any startup can approach them. They can have their guidance. They will advise them how which category it falls, how to file it, how to file in the foreign countries. All the kind of guidance, advice and assistance in the process of filing also is done by facilitator without a single fee, because the fee will be beared by government of India. And the startup can readily approach them, take all kind of guidance. Only they have to pay statutory fee regarding the application, whatever the actual fee of the filing procedure, they will have to pay. But for the service that is provided by facilitator in the form of helper, guide and assistant, he that would be beared by government of India. Eligibility of a startup, you must be knowing, it is based on many criteria by DIPP. A certificate of recognition for startup is given by DIPP. So anyone having a startup certificate can use this facility. Further, their fee is also different. Like a normal company will have a almost a four-time fee. The startup is considered as an individual, and thus they are uh, they are given the benefit of reduced fee. So these are the scheme that government of India promoted used to promote startups, and those can be used by any of you that are there in startups. uh, Now we are moving ahead with the quiz, but I may like some answer in the chat box, or wherever you can do it. I'm just in the chat box for any question. Uh, Trade secret. I saw a question here. Uh, Trade secret is not managed within the IPR policies. It is something that it is an option that one have, that Yes, it is an option that one have, like a company has come up with some invention, and they do not want to share it with public, because if they share it with public under this existing protection regime, it will be open for anyone to use after 20 years. But the company thinks that their invention or whatever they hold is of far more importance, and they do not want to share it, then they can go for trade secret. But the thing is, that it is their responsibility to keep it secret. So whenever they hire employee, they will sign something like a non-disclosure form. But something happens and the third party somehow knows their secret, then they can freely use it. They cannot ask them, they cannot challenge them. They can only sue their employees who have done some wrong. So this is the problem. The whole responsibility of keeping it secret uh, remains with you. And in the case of patent, if someone else is using, you can approach to court. But in this case, you cannot approach to court against someone, because it was your decision that you will keep it secret, and you failed in that. Only you can sue the person with whom you have been in contact with your employees. So I'll also give you example. Everyone, most of you must be knowing about, in fact, the Coca-Cola formula, almost a century old, and they haven't disclosed their formula, and yet they are continuing with it successfully. It hasn't come out. Similarly, KFC, their recipe is a trade secret. So this is all about trade secret. And let me go through more questions. Sorry, two-person are working on the same type of drug invention, and among them one passes the patent mark before them. Then how the work of other inventor will be evaluated? So there is a question that two-person are working on same drug, or we cannot we should not take only drug, any kind of invention. Two-person are simultaneously working, and the one person comes before the other, then all we are going to realize is who came to us first. So it's a first come first service basis. And uh, suppose there is some evil play in this, that the person was behind it, but somehow he used wrong tricks and the other thing influences to obtain the other's invention. Then the route he can take for any kind of remedy is court. He will have to prove that the second person have wrongfully obtained his invention. So this is a court matter. But as far as we are concerned as a department, whoever comes with to us with the invention first, that date is noted down as a priority date. And anyone coming later on with the same invention, he will be rejected. So it is simple case of first come first serve. And is it actually possible to offer protection to smell fragrances under smell mark? Yes, it is possible. Smell mark, I told you, is there are already existing examples of smell marks. But in India, there has been no example of smell mark. It's only what I am talking about is globally. In foreign countries, there has been instances of smell mark, but not in India. In India, probably because it is not easy to write it down. To whenever we file application, there is no it is difficult to represent it in the filing procedure. So in India, there has been no instances of smell mark, but at global level, we have seen examples of smell mark. Mm. Acha, the question continues regarding the smell mark, because many people copy notes of perfume and recreate them into less price perfume products. So regarding the same, I want to clarify with the example that a person, a company dealing with fruits cannot trademark his company as a in the name of apple or say mango, because the category in which they are dealing is fruits and vegetables, and so any product from that category cannot be anything that represents the same thing cannot be taken as a trademark. So a company dealing with fruits and vegetable cannot have name apple, yet we know that we have a company called apple, which deals with electronics. So it's a part of to remove any kind of confusion. This is a restriction set in the act that the anything which represents the actual category, the category of the product you are dealing, you should not name the same. So by that logic only, when you are asking this question that can we smell mark under the smell mark for protecting the perfume, so you cannot, because simply you cannot go for anything to register anything which belongs actually to your category of the products. So perfume, perfume industry is dealing with the perfume, they cannot go for a smell mark. Smell mark is just to give you reference that yes, this mark belongs to this company. Can you relate the analogy I gave regarding Apple, which is not a company having that field of business cannot register in the name of Apple, but a company dealing in electronics can have the name of Apple. Similarly, a company dealing in perfume cannot go for a smell mark. One question is, what about trade secret? Is it not intellectual property? It is intellectual property, but not managed officially by government, because there is no kind of disclosure. So when you are not disclosing anything, no rights and what kind of assistance probably you will require, because you are keeping it secret by own. So just government allows that okay, you keep your secret with yourself and manage it by own. So government does not have any role to play with trade secret. It is allowed though, not illegal. RGN IPM, yes, it provides on. Question is there? Does RGN IPM Nagpur provides online training program? It does. At time to time, different kind of online programs are there. Even with international organizations, there are tie up. So you can just check all the available courses at time to time. It keeps on changing. Uh, uh, there is a Okay. This form can only be viewed by users in the this.
Okay, so the question is by from Ria Kamble, that is, can inventions be protected only by patent?
Um, okay. Can inventions be protected only by patent? Yes, inventions. Um, what happens that more difference I will like to clarify between copyright and patents. Patent protects the idea. Copyright does not protect the idea. So you came up with a unique kind of idea, some novel idea, and you wrote down in your book. Now you have published that book, you got the copyright. No one will be using same exact words and the same book, and you have the right regarding the book and the exact wording written in those. But suppose someone is using the idea that is written in that book, that is open for public use. So the protection of copyright is limited to the expression of idea, not to the idea. While in the case of patent, whatever the idea was, something inventive probably, so that idea is also protected. It doesn't mean that what exact words were written in patent. If you are dealing with a say a particular drug in your case, uh, then this whole whole idea, as in this whole composition will be protected. And in the case of copyright, you are writing something about drug, that this is the composition, and these are the benefit and all. So it will be considered a literary work. uh, the exact word to word copy, anyone cannot copy those word, or even like there is a margin given, 90% of the work, or say 80% of the work cannot be copied. But the idea is not protected in the case of copyright. Trademark is not at all about invention. So only thing one can protect is one can protect invention is patent. Am I missing any questions? I'm just going through a link.
Sir, I think there is are no more questions.
Okay, okay, but still, I had this quiz. I was supposed to take question after this, but not a problem. Um, so you have a slide here in front of you, and there are some jumbled letters. Just have a glance over it, and you will find some day-to-day life trademark that you see in your life. And I'll give you 2 minutes. I'm sure you will come up with some brands in these jumble letters. So by now, I hope that you must be able to see Amul is there in this. Then we have Dettol also, and we have Pepsi, and Horlicks, Bata, and Tata is there. So the here the sense was that out of the those, yes, Babool is also there. So out of those jumbled letters, we recognized the things we have seen in our daily life. So this is the power of trademark. That's why it is important in a word, in a market. When you go out and you just see something unrecognized, you won't go for you won't have a trust. But when you see Amul, you will have trust. So this is the game of trust, which is protected by trademark. Now here in this slide, there are. I want you to identify which picture belongs to which kind of IP. Like first, Mona Lisa painting. What does it belongs to? Which category of IP it belongs to? It must be easy. It is copyright because it is painting, and I have told directly that painting and all comes under copyright. Again, the second being sculpture. So here the doubt may come that whether it is copyright or design, because it looks like a product also. So for that, I'll help you out, that use the definition that I told for design, that there is an existing product, and on that art has been performed. In this case, the whole art is about sculpture. If the art is taken out, nothing is left. So this is the case of copyright. In design, take the example of a car. If we take out the design, still the car is there, product is there. So that was design. My first example, the fan with the curved blade. If we take out the artistic work there, then also the fan is there. But in the case of sculpture, if I take out the artistic work, that is the sculpture, nothing would be there. So this is the case of copyright. Third, rightly told, it is the case of patent. Fourth being trademark, and fifth is a case of multiple categories. So trademark is quite obvious here, Coca-Cola. But one thing you may not be knowing, that this design has also been registered. means other company say the design has not been registered. In that case, other company can come up with their own logo, but the shape of bottle would be same in the red tag. So that will cause deception in the public, that public will see a bottle same shaped with red label. They even sometimes they won't go for reading the name. So this is the case, how duplicacy is promoted. So to stop that, Coca-Cola have registered the design also, so the competitor cannot have a similar shaped bottle also. So trademark is there, and design is also there in the case of fifth picture, and trade secret, as we already discussed, is also there in this Coca-Cola case. Few question: which type of IP protects the painting painted by artist? I won't wait for this. It's a simple case of copyright. Which protects the what protects the intellectual property created by fashion designer? So this I like you to answer. I got the answer, design. So that is right, design, because yes, because the cloth was already there, and some art, some kind of creativity was performed on the cloth. So this is the case of design. What protects the advanced disc brake of bike developed by the inventors? It will be patent. It will be patent because it is about technology. Advanced disc brake, it is not about look. How good the brake is looking does not matter. What technology is being used for the advanced disc brake? So here functionality is involved, some purpose is there, and so patent is the case. Which of these is a geographical indication? BMW, obviously not. Patani sari, yes, it is the case of GI. Uh, Ironing machine is not there, obviously. PlayStation and World Wide Web are not the case of geographical indication. So answer would be Patani sari. What does a trademark protects? That was the simple definition from trademark, that it protects logos, name, and brands. Patent lasts for 20 years. I won't stop for this. If you write an original story, what type of intellectual property gives you the right to decide who can make and sell copies of your work? So this is a classic case of copyright. I told you copyright have a bundle of right. Bundle of right means not only the right regarding that book, but also regarding the translation of that book, adaptation of that book, and all the relevant neighboring rights. So this is the case of copyright. Imagine a cricketer set up his own company to sell his own range of clothes. What type of intellectual property can he use to show that the clothes are made by his company? And I'll tell you, this is based on real life example, and even I'll like you guys to recall. Can you recall any cricketer who have set up his own range of clothes? Virat Kohli. Virat Kohli have set up his range of clothes named wrong. Then Dhoni is there, whose range of clothes are called seven. So these are the case where the quality of clothes comes in the form of image of cricketer. Okay, cricketer is not actually going to give specific art in the clothes. So the other question which we earlier took, by a fashion designer was doing artistic work on clothes. But here what is happening, the image of cricketer is being used to promote a cloth. There is nothing being told about clothes. It is the image of cricketer that is attached to this cloth. So it is about trademark. Trademark is always about image, particular image. Dhoni have a image, and that is being linked to a range of clothes. So it's a case of trademark. If a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying the invention? And that is obviously patents. Oh, so that's all from the presentation. Any question is still left can be asked.
So no, I think all questions you've
Okay, okay,
answered it.
okay.
Thank you, sir. It was really an informative session. Your simplicity level to explain the concept was really appreciable. I'm sure that all the participants have got their all concepts very clear. Now, I request Poonam Patil ma'am to quote the vote of thanks. Over to you, ma'am.
Okay. Thank you, Pratiksha madam. I feel honored to get this opportunity to propose vote of thanks for today's program. So I, Poonam Patil, Assistant Professor, IIC Coordinator of KGRDCP, on behalf of Konkan Gyanpet Rahul College of Pharmacy and Research Institute, extend a very hearty vote of thanks to very first Government of India, Ministry of Commerce and Industry, DPIIT, Office of the Controller General of Patents, Designs and Trademark, and Indian Patent Office, Mumbai, who agreed to our request for conducting this workshop on intellectual property rights under NIPAM, that is National IP Awareness Mission. Next, my sincere hearty thanks to our Mr. Prakhar Singh, our resource person of today's workshop on intellectual property rights, for enlightening participants on IP rights. Sir very nicely explained patent, design, trademarks, geographical indications, copyrights, etc. by giving day-to-day examples that we came across and handle. Further, Sir also explained patent filing procedure and examining application. Sir has also shared that there is a traditional knowledge digital library where uh, Indian patents are mentioned. Surely, sir, we are going to visit that. And very importantly, sir has shared the lease shared that to file an intellectual patent for a startup, where the high fees are taken by the agents. So felicitators are the provided by government of India. So surely, sir, we will take benefit of this, and also participant students will take benefit of this. Those who are not going to pay a single penny for processing the patent for their innovation. And lastly, sir has shared a quiz session. I think the participants have enjoyed that and further clarified their concepts. So thank you very much, sir, for your valuable time and your sharings on intellectual property rights.
Yes.
Uh, and I think the objective of encouraging participants for innovation and startup, and also the knowledge to protect their innovations with IP rights, I think this is achieved with the help of this workshop. Next, my sincere thanks to our principal, sir, Dr. Mohan Kale, sir, whose guiding vision always motivate us to strive for the best. And I would also like to convey my special regards to the management of Kokang and Pit Rahul Daga College of Pharmacy, without whose support the event wouldn't have been possible. I would also like to thank all the teaching staff and non-teaching staff to put their persistent effort to make today's program successful. I am also, lastly, very important, I would like to share that the total 303 participants registered for this from all over the India. So thankful to all the participants that you always attend our online sessions and encourage us to organize more and more such events for you. So thank you participants for your active participation, and I think all have feedback link which have been shared in chat box. So here I conclude that today's workshop on intellectual property rights is over. And thank you once again for your cooperation and active participation. Have a great day ahead. So thank you everyone.